Factual cause means that if what the defendant does ultimately led to the injury of someone else, he is liable. He may not have been responsible for the immediate cause of injury, but the act must be the first in the direct line. Foreseeable harm means that to be liable, the harm must have been foreseeable. The defendant does not have to know exactly what would happen, just the type of event. In some cases, the defendant must prove that he was not negligent, or the facts imply that his negligence caused the injury. For a plaintiff to win, he or she must show genuine injury. Future injury may also be compensated, but this must be determined at the time of trial. A bystander, even if she is unharmed physically, may recover for emotional distress if she was near the scene of the injury and this caused her immediate shock because she was a close relative of the victim. Damages are usually compensatory. This means that they are designed to restore what was lost. In unusual cases, they may be punitive. In a few states, if the plaintiff is at all negligent, he cannot recover damages from the defendant. This is referred to as contributory negligence. In most states, however, if the plaintiff is negligent, a percentage of negligence is applied to both the defendant and the plaintiff. This is referred to as comparative negligence. The plaintiff can recover from the defendant to the percentage that the defendant is negligent. In some cases, a plaintiff found to be more than 50% negligent cannot recover at all. If a person voluntarily enters a situation that is obviously dangerous, she cannot complain if she's injured. This rule applies to a situation where the danger is well known and the person chooses to be there. The next time you're out and about, try to find a negligence suit waiting to happen. Try to find some careless maintenance, unsafe condition, or other unreasonable behavior that's inviting a problem. Are the university stairs in satisfactory shape? Are the doors in your apartment secured with a lock and is visitor access controlled with an intercom system? Are sidewalks shoveled free of snow when you leave? Does your employer maintain a safe workplace? At a construction site, are pedestrians exposed to any dangers? You should be able to find several instances of unreasonable behavior. You've probably heard about the lawsuit in which Stella Liebeck sued McDonald's for burns she suffered after spilling a cup of its takeout coffee in her lap. But I'll bet that whatever you know about the case is either wrong or incomplete. You may have also seen a chain of emails about the Stella Awards, named after Liebeck. Its message is that the tort system is out of control. Whatever problems exist with the tort system are not revealed by the stories in the Stella Awards email because none of the stories are true. All are urban legends and they've been circulating online for years. As for Liebeck's suit against McDonald's, what most people don't realize is that the coffee that burned her was 180 degrees, 20 degrees hotter than coffee typically served in restaurants. The jury considered whether McDonald's acted improperly in selling 180-degree coffee, which was significantly hotter than a consumer would expect from their common experience. Stella Liebeck incurred third-degree burns, received skin grafts, and spent 7 days in the hospital. Testimonies at trial showed that before the lawsuit, McDonald's had received over 700 complaints about burns, some of them third degree, suffered by customers who spilled coffee on themselves. A McDonald's executive testified that McDonald's knew of the risk of burns caused by its hotter-than-average coffee and knew that most customers didn't realize the specific risk posed by coffee at those temperatures, but nevertheless didn't intend to warn customers of the risk. The suit was not about a mere failure to warn that coffee is hot. It was about the failure to warn about the danger created by serving materially hotter than normal coffee to customers who knew they were buying something hot, but not that hot. With any case, it's important to really think about the concept of duty of due care, and we should also take the time to learn the facts before passing judgment. While many lawsuits are completely warranted, there's a good case that many are not justified and the price paid is far too high. In March of 2006, Tillinghast, a consulting unit, issued a report that put the annual cost of the American tort system at $260 billion, almost equal to the annual sales at Walmart. This is the end of Chapter 7 lectures. After you do the reading, you should be all set to complete this week's assignments.